podcast, I wanted to try and compare the state and federal judiciaries. As you're certainly aware, there are both federal and state judicial branches of government with separate court systems at both of these levels of government. The federal courts are established in Article 3 of the United States Constitution, while California state courts are established in Article 6 of our state constitution. Article 3 of the federal constitution contains 3 sections. Section 1 vests the judicial power of the country in the Supreme Court and the inferior courts, that is the lower courts, that Congress shall establish. Article 3, Section 1 also specifies that there are no term limits for federal judges. Note that Section 1 establishes the Chief Justice, but not the size of the Supreme Court or other specific positions. Congress has used its power set forth in the U.S. Constitution to establish the 13 U.S. Courts of Appeals, as well as 94 district courts around the country, and the U.S. Court of Claims, as well as the U.S. Court of International Trade, the U.S. Bankruptcy Courts, which handle bankruptcy cases, obviously, and magistrate judges who handle some of the district court matters. Article 3, Section 2 of the U.S. Constitution sets forth the powers of the federal courts. First, the judiciary is required to consider only cases, actual cases or controversies, which is why federal courts utilize the issue of standing, mootness, or ripeness to limit their jurisdiction over federal court cases. Essentially, federal court jurisdiction is limited to cases that arise from the federal constitution or federal statutes, as well as treaties or those that involve multiple states or foreign governments and certain specified areas such as bankruptcy. The Supreme Court has original jurisdiction with ambassadors or when the states are a party to a case. And juries must be used for federal criminal prosecutions according to Section 2. Article 3, Section 3 defines treason and specifies that Congress must punish it. And there are specified requirements for cases of treason and how they can be published or punished. All state constitutions create their respective state court systems naturally, and they all have a high court, and many states have an intermediate appellate court, as does California. All of them also have trial courts naturally, and some of those are called circuit courts or district courts. Most states also provide for courts that handle certain legal matters, such as probate cases or family law matters. So turning to Article 6 of the California Constitution, it contains 23 sections, although numbers through 22. Section 1 vests the judicial power of the state in the Supreme Court, the Courts of Appeal, and the Superior Courts. Section 2 of Article 6 specifies that there are 7 Supreme Court justices, and Section 3 requires the legislature to divide the state into districts, with each of those districts having a court of appeal, and there are 6 today in California. Section 4 requires each county of the state to have a superior court of 1 or more judges, and the legislature prescribes the number of judges and also provides for the officers and employees of each superior court in those 58 counties. Section 6 creates the State Judicial Council, which appoints an administrative director of the courts. Section 7 creates the Commission on Judicial Appointments, and Section 8 creates the Judicial Performance Commission. Then Section 9 creates the State Bar of California, which is a public corporation, and every person admitted and licensed to practice law in the state of California is a mandatory member of the State Bar. Section 10 of Article 6 of our state constitution specifies that the Supreme Court, the Courts of Appeal, the Superior Courts, and their judges have original jurisdiction in certain types of proceedings. Then Section 11 provides that our state Supreme Court has appellate jurisdiction when the judgment of death has been pronounced by a trial court. Section 12 deals with appellate court jurisdiction. And then there's section 15 that makes a person eligible to be a judge of a court of record only with at least 10 years of immediately preceding their selection that they've been a member of the state bar or served as a judge of a court of record in the state. Section 16 specifies that judges of the Supreme Court are to be of the Superior Court are to be elected at large, and judges of courts of appeals must be elected in their districts at general elections at the same time and places as the governor. Section 16 also limits terms to 12 years and specifies how the justices are selected. In section 17 of Article 6 of our state constitution, it prohibits a judge of a court of record from practicing law during the term for which the judge was selected, and also makes the judge ineligible for public employment or public office other than judicial employment or that judicial office. Section 18 requires the disqualification of a judge when certain proceedings are pending before that judge. Section 18.1 requires the Commission on Judicial Performance to exercise discretionary jurisdiction with regard to the oversight and the discipline of judges of the courts of record. Section 20 specifies that the legislature must provide for the retirement of judges as well as the courts of record for age or disability. And Section 22 allows the legislature to provide for the appointment of trial courts of records of officers such as commissioners to be allowed to perform subordinate judicial duties in the state. Now, when it comes to the selection of judges, the US Constitution states that federal judges are to be nominated by the president and confirmed by the United States Senate, and they hold office typically for life. Through congressional impeachment proceedings, federal judges may be removed from office from this behavior. On the other hand, in California, state court judges are selected in several different ways, such as election or appointment by the governor, and they do so for specified terms. In California, the trial court judges are elected generally, but the governor does have the authority to appoint judges to fill vacancies. For appellate court justices, the governor appoints them, and they're confirmed by the Commission on Judicial Nominations. Finally, regarding court jurisdictions, the federal courts are assigned cases that deal with things like the constitutionality of a law, cases involving the laws and treaties of the United States, cases involving ambassadors and public ministers, disputes that occur between two or more states, as well as cases involving specialized areas such as admiralty law and bankruptcy law. State courts, on the other hand, handle mostly criminal cases, but also things like probate, contracts, torts, and family law matters. They also decide on cases involving their own state constitutions, as well as interpretation of their statutes and regulations.